Dear students, we have been learning about law, but we should know about some case studies as well. After studying this module, you will be able to gain knowledge via case studies, understand and experience proceedings, know the evidence in India and its applicability, discuss hand in hand basics of evidence collection and documentation. First, what is evidence? Evidence is anything presented in support of an assertion. The support may be strong or weak. This assertion is the outcome of the perception made by a person out of his any of the senses. The strongest type of evidence is that which provides direct proof of an assertion. In law, the evidence governs the types of evidences that are admissible in a legal proceeding. Types of legal evidence include oral testimony, documentary evidence and physical evidence. Uncorroborative testimony is admissible. The term uncorroborated means unsupported by any other evidence. First, we will talk about the fingerprint evidence. Of all the methods of personal identification, fingerprint alone has proved to be flawless and sufficient. Its superiority over all older and modern methods has been demonstrated over the years. So far, the fingerprints of no two individuals have been found to be identical. Fingerprint experts consistently refer to Galton's calculation showing the evidence of 64 billion different fingerprints. Even the two identical twins, which cannot be distinguished using DNA analysis, can be identified by their fingerprints. This is the most reliable method of identification accepted by the whole and being used by all countries of the globe. With regard to evidentiary value of fingerprints, it has been established that the evidence furnished by fingerprints is regarded as conclusive and may be acted upon provided the court is satisfied that there is no possibility of a mistake in the opinion of the expert. In spite of alteration of fingerprints by plastic surgery, the identification of the criminal has been possible by the characteristics of the second joint finger. Some of the observations of the courts are detailed. A. Thumb impression is an exact science. An observation has been made that the science of identification of thumb impression is an exact science and not subjected to any doubt or mistake. All India Reporter, 1979, Supreme Court, 1708. Next is, what is the duty of fingerprint expert in court? In All India Reporter 1960, Andhra Pradesh 160, the court held that it is the duty of the fingerprint expert who has been examined to explain how he has come to the conclusion. It is the duty of the court to scrutinize the evidence or make a comparison of the impression personally. In the case of Sitaram Rajput of Madhya Pradesh 1978, Criminal Law Journal 1220, the court noted that it cannot be laid down as a rule of law that it is unsafe to have conviction on the corroborative testimony of a fingerprint expert. The true rules seem to be one of the caution. The court cannot delegate its authority to the expert but has to satisfy itself as to the value to be given to the evidence of the expert in the same way as to the given value to any other evidence. The reasons given by the expert are ultimately to be weighed by the court and satisfy itself about the corrections of the conclusion by the comparison of the prints. Next is, court can direct accused to give thumb impression. In B. Ramareddy of State of Andhra Pradesh 1971, Criminal Law Journal 1591, the court was in agreement with the reasoning of the full bench of Patna High Court, which held that the direction of a magistrate to accused person to give signature, handwriting specimen, thumb impression, fingerprints or footprints for comparison will not amount to compelling the accused persons to be witnessed against themselves and would not be hit by the Article 20 subclause 3 of the Constitution. Now we will talk about footprints. Footprints are the impressions or images left behind by a person walking or running. The print left behind at a crime scene can give vital evidence to the perpetrator of the crime. Shoes have many different prints based on the sole design and the wear that it has received. This can help to identify the suspects. Photographs or castings of footprints can be taken to preserve the finding. Analysis of footprints and shoe prints is a specialist part of forensic science. Section 45 of Indian Evidence Act does not include foot impressions or footprints as it does fingerprints or finger impressions. Footprints have not been properly classified, nor any significant rules for their classification is made. As such, it is quite right to say that footprint science is a rudimentary science. Such an observation have been made by court in the case of Pritam of State of Punjab, 1956, All India Reporter, Supreme Court 415. Reliability of footprint evidence. Footprint evidence is weak evidence when seen in the light of the fact that they cannot be classified, as there are no agreed laws for their classification, making its reliability highly unsafe. In case of Kapil Singh of State of Bihar, All India Reporter 1969, Supreme Court 53, while referring to the prosecution relying on the identity of the blood-stained footprint with that of the sample footprint, the court accepted the observation of High Court, which held that the evidence's very nature is a very weak type of evidence and it would not be safe to rely on this evidence and discarded it. Next is handwriting opinion. It was held that the expert opinion on handwriting was only the opinion evidence and does not help the court in interpretation. This was said in All India Reporter 1994, Supreme Court 120. It is an accepted principle of law that the science of handwriting was not an accurate one and possibility of errors creeping in it is when a handwriting expert gives evidence. Next type of evidence is dog tracking evidence. Tracking dog evidence is a weak evidence. It cannot be compared with scientific evidence tendered by experts under Section 45 of Indian Evidence Act describing microscopic evidence, blood tests or chemical reaction. In the case of Abdul Razak, State of Maharashtra, All India Reporter 1970, Supreme Court 283, it was held that the tracker dog's evidence cannot be linked to the type of evidence tendered by scientific experts. Next is lie detector evidence. Lie detector is a misnomer. The instrument does not detect lie by itself. It is the forensic scientist who analyzes and interprets to ascertain if there is any deception or not. Reliability and usefulness has been discussed in detail in the relevant chapters in polygraphy along with court evidence and may be studied from there. Next, medical doctors. The most frequent use of expert opinion in criminal proceedings is possibly the evidence of medical person on various questions confronting the court. Their opinion is required in a variety of subjects in criminal cases such as cases of death, identification of human remains, insanity of person, self-inflicted injury or otherwise, identity of the person and certificate of illness, etc. A medico-legal report is divided into two parts. One part contains a statement of facts and the second part contains opinion or inferences drawn from the facts. The report of medical expert is inadmissible unless he has been examined. Medical evidence is recorded under Section 45 of Indian Evidence Act. In case medical evidence conflicts with direct evidence, the court can either believe the prosecution witness unreservedly or explain the conflict by holding that the witnesses have merely exaggerated the evidence or rely upon the medical evidence and approach the oral testimony with caution testing. It is the light of the medical evidence. Certificate of illness and medical doctor. All India Reporter 1986, Orissa 102. In Nityanand Maji versus Supradas, evidence of defendant producing doctor's certificate in support of his plea of illness on the day of hearing of suit in the trial court, it was observed that absence by any indication in certificate that defendant was unable to move during certain period is not fatal to plea of illness, holding that no medical officer indicates in certificate exact condition of patient. Next is exact age of injuries not possible by the medical officer to be opined. The opinion of the doctor with regard to age of injuries cannot be exact. The opinion of the doctor, though he is considered to be an expert, cannot be considered to be conclusive evidence. In medical science, the age of injury may be examined and appropriate tenure of time can be ascertained. The opinion may not be exact and allows concession of some time upward and downward. Shanabhai Madhurbhai Kohli, paid of state of Gujarat 204. Doctor's opinion not relied, Prem versus Dola, AIR 1997, Supreme Court 715, was observed that the doctor who conducted the post-mortem on the dead body expressed doubts on the nature of injuries that could have been caused by weapon of offence. The doctor was found to have given opinion in a very casual manner. The evidence of 3 eyewitnesses was relied upon. Very important aspect, unprofessional conduct of doctors. Court in Karnataka disclosed highly unprofessional conduct of doctors, wherein they got won over by rapists, resulted in the acquittal of 94% of rape cases in the state. As disclosed in a strongly worded judgment in a case of the state of Karnataka, Rangaswamy 2003 Criminal Law Journal 607, which is detailed, we need to take note of the fact that in this, as in all other rape cases, there are not going to be an eyewitnesses, nor are there going to be witnesses to the actual incident. Invariably, the court is required to accept or reject the testimony of the victim, and if the evidence is good enough, it is usually supported by the medical evidence and forensic evidence. This court has found that time and again the medical evidence is almost every case of sexual assault on women is tampered with, and the doctors come out with the evidence that can only be termed as pro-accused. It does not require much intelligence to see through these malpractices. This clearly indicates that there is a very serious integrity problem at this level. We don't propose to close our eyes to this state of affairs and direct the government to immediately formulate adequate safeguards to ensure that there is a full stop to these illegalities. Now we will talk about photographic evidence. Photographic evidence. Role of photography is very significant in forensic science at the crime scene as well as in the laboratory and the court. A very famous proverb, one picture is worth 1,000 words. According to section 9 of Indian Evidence Act, photographic evidence is admissible to explain or introduce a fact or an issue. Evidence of identification by a way of photographic superimposition is admissible under section 9 of Indian Evidence Act. Now we will talk about trace evidences. Trace evidence may be invisible, but it can be appreciated in the light of Locard's principle, which is termed as principle of exchange. Locard's principle is stated as follows. Whenever two entities come in contact, there is an exchange of traces mutually. This law of exchange or principle was first enunciated by Edmond Locard and is also known as Locard's principle of exchange. In an attack on the life of the Honorable late Prime Minister Indira Gandhi, a sharp actuated knife was thrown on her by one Lalwani who had hidden the same in his pocket after wrapping it in a paper. The case was registered in Parliament Street Police Station, New Delhi, and the trial started. The person who had examined the paper and knife tendered his opinion on the basis of trace elemental analysis of chromium on the paper that was invisible and on the chromium plated knife. Lalwani was found guilty and awarded punishment by the Honorable Court. Now, voice identification evidence. Voice identification evidence. Facility of voice identification using sound spectrograph had been introduced in the CFSL CBI New Delhi in the year 1985. Most of the opinion given by voice experts in Indian courts were relied upon, where as in a few cases opinion were not given due to importance or resulted in the non-acceptance of the same. Perhaps no specific laws have so far been made regarding its acceptability in courts in India, as is the case with lie detector evidence. The Honorable Supreme Court observed that no attempt has been made even to mix voices of the convict with the appellant with some other unidentified voices. In such circumstances, held High Court committed grave error in confirming conviction of appellant only on evidence of voice identification. Hence, appellant entitled to benefit of doubt as prosecution failed to prove its case beyond doubt, Maharashtra Control of Organized Crime Act 1999. It is fair to mix the recorded voice of an accused with some unknown recorded voice for making an unbiased comparison and then arriving at any conclusion. Next, what are eyewitnesses, expert witness and chemical examiner? An eyewitness certifies what he sees. He cannot draw any conclusion except to state what he had seen or what he has observed. An expert witness can combine after he observes, examines something, but he would be cross-examined by the opposite party and has to prove to the satisfaction of the court regarding his achieved expertise. His opinion in the court is admissible but not in his absence. The chemical examiner is a government expert, witness and can observe things, analyze the data, draw conclusions and form an opinion, which can be emitted by the court even in his absence. However, the court may call a chemical examiner to the court for tendering opinion and cross-examination. The retired chemical examiner loses his status of being chemical examiner on retirement and is no more a government expert. He is treated as an ordinary expert witness under Section 45 of Indian Evidence Act, who is allowed to give an opinion under Section 45 of Indian Evidence Act, which the court may or may not accept after his cross-examination, which becomes essential in every case wherein he opines. Next is expert opinion. Expert evidence is not conclusive but only an opinion. Expert evidence is to be received with caution. Court insists on corroboration of expert evidence in general. Infirmities of expert evidence are due to limited knowledge, inaccuracy of expression, biased, availability of limited facilities for examination. What is an expert evidence? Earlier, the need of expert evidence was limited only to some limited cases like medical, forensics, finance, etc. With the increasing development in the field of science and technology, the importance of having the expert opinion or evidence has become very useful in the court of law to reach upon a fair and unbiased decisions regarding commission of an offence. The role of experts has been broadened and the courts take their assistance in the various fields such as forensics in DNA tests, ballistic evidences, chemical examiners, psychiatrists, radiologists, and sometimes even cases where the track dogs are playing a crucial part in the line of investigation of the crime, and hence their evidence is admissible in the court of law. When there is some technical issue or such issue which relates to foreign law or of science or art, or as to identify of handwriting or finger impressions, and the court has to form an opinion upon that point, then the opinion of skilled or experienced persons in their respective areas may be taken into consideration. Now, few considerations regarding the testimony of an expert are: first, expert evidence is an opinion evidence and not a direct evidence and hence weak. In a case of Shamim Rahman, state of Uttar Pradesh, a ballistic expert tendered the opinion that the 2 empty cartridges could have been fired from the 20-bore double-barrel breech-loading gun. This is not a definite opinion. The Honorable Court observed some other facts like presence of empty cartridges found at the scene, and on appreciations of this evidence as a whole with the background of other facts and circumstances, felt that there was no shadow of doubt that the double-barrel breech-loading gun that had been used in firing the shots. Expert evidence and corroboration. Expert evidence being an opinion and weak evidence needs corroboration. The Honorable Supreme Court observed that the expert opinion has to be corroborated by other evidences. All India Reporter 1957, Supreme Court 318, and All India Reporter 1963, Supreme Court 1940. Expert opinion and reasons. Expert must give reasons in brief along with his report. Courts are not bound to accept opinion of an expert. They can and do reject opinions of expert, including government experts. Experts give their opinions to assist the court and cannot decide any issue. It is for the court to decide. In All India Reporter 1974, Supreme Court 308, it has been observed that if conclusions reached by experts are unsatisfactory, the court is not bound to accept it. Expert opinion gets its weight and authority when experts points before the court all the materials which induce him to produce to the conclusion, so that court may form its own opinion on those materials. Expert evidence is a weak evidence. Expert evidence is weak evidence. It needs to be corroborated and cannot be conclusive proof entirely. In the case of S. Gopal Reddy, State of Andhra Pradesh, it was held that the evidence of an expert is rather a weak type of evidence, and the courts do not generally consider it as conclusive proof and safe to rely upon the same without seeking independent and reliable corroboration. Expert in the court. The expert is not a witness of facts only. He should give significance of facts and submit his findings to court to assist it and function as an advisor. The expert is neither for prosecution to function as a prosecuting witness and nor for the defense. He is witness of the court. The scientific opinion be expressed in simple language to make it understandable and convincing with sound reasons so that they get due consideration by the courts. Court may not place any reliance on an expert opinion which is unsupported by sound reasons. The scientific data and other relevant material like reference from book are furnished to the court, which would form basis of his conclusions to archive his credibility. He should provide the court necessary scientific criteria for testing the accuracy of the conclusion with clearly stating margin of error in his experimental work. The report of the expert does not go into evidence automatically, since an opportunity would be normally provided to the defense to examine the expert and has his cross-examination conducted in the court as observed in case of V. Jailal, State of HP in 1999-7, Supreme Court 280. Difference of opinions expressed by two experts. Difference of opinions may occur in the cases. First, government expert and private expert may be engaged by defense, between two private experts, between two government experts. Regarding first and second, the two important judgments relevant to the issue are produced in Criminal Law Journal 810 HP, State of Himachal Pradesh, where conflicting opinions expressed by the government expert and the expert produced by the accused, it was held that the opinion of government expert was more reliable. When two experts are giving evidence in different manners, the opinion of the one who has better qualifications and experience in the particular subject under the enquiry will be preferred. This is in All India Reporter 1965 Supreme Court 365. Regarding third, though it is a rare case where two government experts differ and give divergent opinions, but this can happen and does happen. The author is aware with many such cases which get a clear signal when it gets examined by a third expert. Under section 482 of Criminal Procedure Code, the High Court is vested with inherent powers to call for second report from chemical examiner. In 1974 Supreme Court 409, it was held that in the case of an excise inspector who has put in 21 years in that position and had examined lakhs of samples of liquors and illicit liquors is fit to be regarded as an expert within the ambit of section 45 of the Indian Evidence Act. After reading this module, you will be able to understand the term evidence and its importance in a legal proceeding, the different types of evidences like fingerprints, footprints, photographic, polygraphy and their relevance in a case, the differences between an eyewitness, an expert witness and a chemical examiner. Understand the term expert opinion and throw light upon its importance in the court of law.